having business with the appellate, which is going here, give your attendance, and you shall be heard. Please be seated.
Okay, good afternoon, everyone. I've been told, or I have big, bold letters here, over 4 hours of scheduled argument time. I'm not so sure you guys want to be here for 4 hours. So, that said, same spiel, we've read everything, we know everything, ask for the time that you'll need. The clock is for you, not for us. Having said that, first case up, People versus Davis Burgos.
For appellant, 3 and 1, please.
3, 1, and 3. You know this point is conceded, right? All right.
Yes.
Okay, fine. 3, 1, and 3. Second case up, Bokhari versus Schwartzberg.
Appellant, having received an email yesterday afternoon upon returning from court that the respondents will not be appearing to argue in each and both of the two cases, may I respectfully request 1 minute each.
1 minute each. Okay. How many appeals are there? Well, one appeal is dependent on the other appeal, right? So why don't we combine them and I'll give you 2 minutes, okay? All right. Because if I set this for 1 minute, by the time you get up here, it's 1 minute's up. Okay. Curtis B. Okay, so hang on a second. Who's the appellant? The appellant's not here today. So, did you cross appeal? No, so, you represent?
Yes, I'm sorry, Your Honor. I represent the child. My name is Louise Felder from the Children's Law Center, and we're supporting the appellate, and therefore I wanted our.
Oh, man, okay. How much time do you want?
8 minutes.
I'm sorry?
8 minutes.
No. So how about we give you, I'll give you 5 and 3 since you're arguing on behalf. It's very strange. You don't represent the mother. You represent the child, but you're here on the mother's behalf.
No, Your Honor, let me clarify. I'm not here on behalf of the mother. My client is the child, and he supported the mother's position and opposed the court's finding against her.
Okay. You're 5 and 3. How much time do you need? 4 minutes. Okay, 5, 3, and 4. You're welcome. Okay. Next case up is Lorensko versus the City of New York. 6 and 2. All right, 6 and 2 and 6. 5, Tudor Peroni Corp. versus City of New York.
Yes, Your Honor, appellate, request 10 and 5, please.
All right, you have 5 and 3 and 5. Thank you. Paterick Tolino versus Ciatia. Okay, how much time do you want? You want rebuttal time? How much time do you need, counsel? All right, I'll give you 5 and 3 and 4, okay? Number 7, Citigroup Global versus SCIP Capital.
For the appellant and the respondent on the cross appeal, 5 and 3, please, Judge.
Yes.
Your Honor, can I have 6 plus 2 for rebuttal on the cross appeal?
Okay, 5 and 3, 6 and 2. Thank you. Functional Life Achievement versus Aspiring Munchkins. All right, I'll give you 5 and 3 and 5. Thank you. Remember, folks, the clock's for you, is not for us, so if we have more questions, even though the light's on, you will still continue to make your case. Next case, People versus Mark Yates. Oh. Whoa, my hearing is not so good. What? 10 and 5? Respond in 5 minutes. Okay, we'll give you 5 and 3 and 5. I gotta change the. All right, next case, number 10, 3 East 54th versus Chatiris. You don't have anyone here to argue against. You still want to, you want to go ahead? Okay, 3 minutes. Case number 11, Brigham versus Cruz. Okay, 5 and 3, 5 and 3, 5 and 5. The city attorney, you gave us a submission yesterday afternoon. We'll talk about it when you get up here for argument, okay? A little late on this, you know. It was a November decision. All right, number 12, Rafa Chowdown versus Rengen is a submit. We're all good to go. First case up, People versus Burgos. Okay.
Good afternoon, Your Honors. May it please the Court. Nicole Giuglas on behalf of Appellant David Burgos. Pursuant to this Court's decision in People v. Simmons, Mr. Burgos' certification as a sex offender must be vacated, and he should not be required to register.
Right, and did the DA, didn't the people concede to that point, or am I missing something?
The people did concede, though they did assert that this Court's decision in Simmons was wrongly decided, and so I am appearing today to assert that Simmons was correctly decided and this Court should apply it, and
Ultimately, because of the concession, it's not registerable offense, correct?
yes, that is our position.
So that's it.
Yes, if the Court has no questions and would not like
It
to,
was easy when they conceded. Do
then I will have a seat.
we have any other questions for the bench? No? Okay.
Not changing my mind.
Yeah, unless you say, no, we don't take the concession, and then we could go all the way.
Please take their consent.
Okay, thank you.
May it please the court, Alex King for the people.
Right.
Your honors, if you have any questions, happy to answer them.
No, unless you're withdrawing your concession.
No, we do not.
Okay, thank you.
Thank you.
Next case, Bakari versus Schwartzberg.
Good afternoon, Your Honors. It is respectfully offered by appellants as prepared to answer any questions from any members of the panel for the several issues and the obvious importance of the matter to the.
Counsel, would you just state your name and which side? you represent?
Yes. My name is Raymond Schwartzberg, and I am both of obviously Raymond Schwartzberg and Raymond Schwartz, the principal founder of Raymond Schwartzberg and Associates, PLLC. There's a wild card defendant named in this proceeding from the day one, Schwartzberg Associates, LLC. That's a real estate company. It's not even a relative of mine. And the plaintiff has never chosen to correct their pleadings. So that has helped complicate the fact that I did, as a third-party plaintiff, implead a third-party defendant, which is.
Counsel, bottom line is you believe the record here supports your position that you never at any time made any representation to commence any kind of personal injury action on behalf of the plaintiff.
Absolutely.
And not only that, but the plaintiff actually signed a typewritten note to that effect years before the formal 2019 letter.
Twice, Your Honor, May 23rd.
So that's it.
Well, I don't want to be presumptuous, but I'm here to be responsive.
But there was a different finding by the court below.
Well, I want a reversal, yes.
I would think so. Yeah.
Yes, I
Got it.
I am
Any further
asking for a
questions?
reversal as eminently meritorious. The appellate position being eminently meritorious, yes.
Okay, thank you.
Am I discharged?
I'm sorry?
Am I discharged?
Yeah, well,
Thank
I'll
you.
use the word discharge. Yes, you're free to leave.
My 2 minutes are up either way.
Thank you, counsel.
Thank you.
Next case, Curtis B. Well,
You should be on that.
yeah, you should be on that side. You're trying to confuse me, right?
This is always,
I had my coffee already, so you're not gonna be able to confuse me.
apologize for that.
Okay.
So good afternoon, Your Honors. My name is Louise Feld, and I'm from the Children's Law Center, and I represent the 12-year-old child who is the subject child in this appeal. It is our position that the trial court was incorrect when it entered a finding of neglect against our client's mother, because ACS's case was lacking in two critical ways. First, ACS did not present sufficient evidence to prove that our client's mother was actually mentally ill.
What about the
Second,
auditory hallucinations that were reported by the caseworker?
I'm sorry.
I'm sorry, what about the auditory hallucinations that the caseworker reported that the mother experienced?
Yes, Your Honor, we don't deny that the mother behaved very bizarrely during ACS's visits to the mother's home. That's true, and ACS did present evidence of that. What it did not present is sufficient evidence to show that she was mentally ill, number one, and number two, that there was a causal connection between her mental illness or her bizarre behavior and potential harm to the child. And that's what's required.
Was it necessary to have an expert opine on whether or not she had a mental illness?
No, the law is clear that an expert is not necessary. However, there does need to be that causal connection between the mother's behavior, between her mental health issues, and between potential harm to the child, which ACS absolutely did not show here. In fact, the evidence that ACS presented talked so much about how positive the child's relationship was with the mother. ACS went to the home was safe, the home was clean, the child said he was happy living with the mother, he enjoyed time with the mother, he was unafraid of the mother. That was the evidence that ACS presented.
Who is the child with now?
The child is with his biological father, who is
And how is he doing with the father?
He's doing well. He's been there for 3 years. He does wish to remain in the father's care. That, of course, is separate from whether or not he believes there should be a finding of neglect against his mother, because he did not support that in the trial court and continues to oppose a finding against her. And ACS simply didn't prove its case. It did not provide enough evidence to the court to prove by a preponderance of the evidence that this mother neglected our client. There was no medical testimony, there were no medical records,
The mother herself testified, however, correct?
She did, and
So
she
the
did
court
not.
was able to evaluate her credibility and how she appeared, her demeanor on the stand. So
Yes.
that has to count for something.
It does, although the court made no explicit findings about that, and the mother denied during her testimony that she had any mental health issues, and it's ACS's job as the presentment agency to present evidence of that to the court.
What about the fact that the mother had the child brought to the hospital and examined based on her hallucinations, the things that she was hearing, and the things that basically were in her mind, that he was being sexually abused?
So to be clear, on that particular evaluation, Your Honor, the evidence was incredibly limited. The mother made one statement saying that at some point in the past, because of her concerns, she brought the child to be evaluated at Bronx, Lebanon. ACS did not subpoena or present the records from Bronx, Lebanon, had no information other than the mother's one statement about this one evaluation at some point there was no information about it. And there was certainly no information that this particular evaluation was at all traumatizing to the child or in any way invasive or even registered with him as something that was problematic. So yes, the case law is clear that the court can find that there is neglect if a parent, because of their allegations or their unfounded allegations or their delusions, submits a child to unnecessary medical treatment. But the situation here doesn't rise to that level, because the 2 times that this child was evaluated, once by ACS when he was taken for a forensic exam, and then that other sort of vague time in the past about which the mother told the caseworker, none of those times there was no evidence for any of those times that the child was traumatized, that the child was upset, that there was there was no physical exam during the forensic evaluation. He had a conversation where he said, no one has done anything inappropriate to me. I'm not really sure why I'm here. That's what the evidence showed. So the ACS certainly didn't prove that the mother was mentally ill, nor did ACS prove that there was a causal connection between any of her bizarre behavior and any potential harm to the child.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. Kate Fletcher for the Administration for Children's Services. I believe in this case, the evidence in the record speaks for itself. The mother had extremely vivid delusions that the father, over a period of years, had sexually abused the child.
Was there evidence before the court concerning the ideation that the child had been abused on stage by the father and an actress who's known?
That evidence was before the court. It was in ACS's notes, which were submitted to the court and which the foundation was laid in testimony by an ACS representative.
Kroll,
And
the Child Protective Services individual named Kroll, right? Who
yes,
testified.
Mr. Kroll, and also they had an additional.
Well, did he also, wasn't he did a home visit and the mother was acting out in front of him?
Yes, that is correct, Your Honor. He made a home visit where the mother believed that she heard over the police radio that the child was being abused. She also told him that on that very day, the child had been abused in her home. She clearly believed that the father was engaged in traumatizing behavior in a delusion that directly involved the child and directly involved the child's relationship with his father.
Well, as I hear the argument, maybe correct me if I'm wrong, but I'm hearing the argument that the child testified, there was evidence that the child had suffered no injuries, no mental issues or whatever, and that is some sort of basis there to say that, you know, the finding against the mother was inappropriate and not proper. I mean, what's your response to that?
My response to that is that it's very well established that imminent harm to the child is an acceptable standard for finding neglect. In this case, where the mother is actively pursuing her delusions by taking the child to the hospital, by reporting to authorities the abuse, and by leading her child to be subjected to a forensic interview, all of this shows that she acts upon her delusions, and that places the child at imminent
So
risk.
the reliance on evidence about the child's well-being is immaterial to the finding of neglect as to the mother, then, whether or not she's displaying herself mental health issues. Is that what
I think the mother's mental health issues are so evident from the record in this case, and that is established.
But is there a conflict with the fact that they went to visit the home and the home was clean and the child was happy? I mean, it seems almost like it would have been helpful to this record if there was an expert or some additional testimony other than bare record that went in on this case.
I understand, but I would point out that imminent harm can include both the physical well-being of the child as well as his emotional and psychological well-being.
He was how old then? 8?
He was 9. And so at the time, the child is a 9-year-old child whose parent that they live with believes that the other parent is abusing them and who's reporting that when the child is in the home to authorities that places his mental and psychological and emotional well-being at risk. It certainly threatens the nature of his relationship with the father. And in this case, the delusions are so intimately tied to him, to his well-being, and she is acting out upon them, and that places him at imminent risk. It's true, she took him for x-rays, but that does not mean that that is the only thing that she will engage in. And I think in this case, where we've seen evidence that she does act upon her delusions and that she does act upon them by bringing the child into the delusion, that places the child at risk.
Has this parent been diagnosed with a mental condition, a mental illness?
There's no diagnosis in the record, Your Honor.
There's none.
No.
And no
But
medical records
There's no
either.
evidence that the father engaged in this abuse. And she's adamant that he engaged in that abuse. She also asserted to ACS that the father was suffering from mental illness.
Yes, but the reason why the court found that the child was in imminent risk of being neglected is because she has a mental illness. So we have no diagnosis of that mental illness.
A formal diagnosis under the case law is not required, Your Honor. There have been cases where the level of the bizarre behavior as manifested by the parents' behavior, the testimony of ACS here, the reports provided by ACS, was considered sufficient to establish that the mother or the parent was suffering.
Do you require this behavior to be on one occasion or more than one occasion?
I would point to the case of Catherine M. In that case, we had a mother who believed that there was radioactivity in her home. She reported it. It caused people to come to the home. It caused the child to be brought to the hospital and examined. In that case, it was found that there was neglect because the mother's delusions, paranoid delusions, were placing the child at imminent risk of harm.
And that was only that was one time.
That is my recollection of the case. I'd be happy to refresh my memory and report back to Your Honor.
Okay.
Thank you.
Just quickly, Your Honors, to be clear, in Catherine M., the child stated that the incident when several EMS workers came into the house and took that child to the hospital, in that particular case, the child said that that incident had an impact on him or her. And I'm sorry, I don't remember if it was anxious or afraid, but I do
Yeah,
recall
but
that.
I know you're relying, unless I misheard you, you're saying that in this case here, the child is fine. There's no, apparently there's no issues with the child's physical and mental well-being. And that you're using that as a basis to say that the finding, or you're using that as a factor to consider in demonstrating that the finding of neglect may not have been supportable, right? I mean, that's what you're saying. But I think it's the other way around, that it's not the focus of the child, but you're focusing, at least the case law seems to suggest, that you're focusing on the parent and the parent's conditions and the parent's mental health, right?
The case law is really looking for that causal connection between the parent's behavior and the potential harm or impact on the child.
It's an imminent harm standard, right? I mean, if they believe that the case law, or at least the evidence there demonstrates or establishes that there's going to be imminent harm, that's enough for the finding, to support the finding, right? And this is where the family court's making its credibility determination. She testified in front of the judge.
Yeah, yes, Your Honor, but the fact is that ACS had a responsibility to present enough evidence to the case, to the court, to prove its case. And ACS simply didn't do that. ACS's testimony was very limited documentary evidence. There was no medical records, no therapist, no proof that there was ever
But a lot of those evidence that you're pointing to is not required, right? It's not required and mandated, right?
It's not required. However, the evidence that ACS did present simply wasn't sufficient to show, A, that there was...
They had the CPS person who did the home inspection testify on the stand saying she was erratic. He displayed erratic behavior while he was in the home. And the court credited that testimony. I mean, I think it seems like it could be argued that the court gave substantial weight in terms of that testimony.
And it appears that that behavior occurred on more than one occasion. based on the testimony that was provided to the court.
The caseworker testified about his one visit to the home, and yes, there was documentary evidence from another home visit. But also, each of those instances, when they visited, the child said that there was nothing wrong, and he was happy, and the home seemed safe and clean and appropriate for
But
this
that's
child.
what your analysis is looking, trying to find the answer through the lens or eyes of the child, when it's actually the other way around. You're looking to find the answer, or at least resolve this issue here through the eyes of the mother, not the child. I mean, the child could be fine, but it's an imminent danger to the child because, you know, what he's fine today, tomorrow could be a totally different story.
I'll just note, Your Honor, because I see my time is up, that the documentary evidence that ACS submitted, ACS said that the home was safe and clean and the child appeared well cared for.
Thank you very much. Laura Sirenko versus City of New York.
Good afternoon, Your Honors. May it please the court. I'm Lisa Como for the plaintiff appellant. I'd like to begin, if I may, with the issues concerning the 241-6 claim. Mr. Lourenco testified that there were a combination of factors that caused him to fall and be injured at the time of this accident.
Don't you run into the obstacle of Bezdarek, which is the precedent? Bezdarek is the name of
yes.
the case. When, the integral to the work doctrine, weren't the materials upon
Yes.
which the plaintiff fell integral to the work that was being performed at the time?
I'm actually glad you asked that, Your Honor, because when you look at the court's opinion, all the court addressed in dismissing, and by the way, dismissing the claim on arguments that were never made by the city. The court did that mostly on its own. The city never argued integral to the work. The city really never substantively, and like if you look at page 44 of the record, 1134, 1135, when the city made its motion, when it made its opposition to plaintiff's motion, it really skirted the 241-6 issue with respect to the 23-1.7, which is the regulation I think you're focusing on. And so they really never made any substantive arguments. They never addressed the merits of that regulation. Of course, since the court is reviewing this de novo, we've fully addressed it now. But I think it's very significant that Mr. Lourenco testified there were three things that were part of his trip. He was carrying the heavy beam. He's trying to avoid this ladder that's blocking his path. And he said there was a rock under discarded plastic and there was loose sand. Those are the things that he described as causing his accident. When the Supreme Court dismissed the claim under the 23-1.7, which is the D slipping and E tripping passageway and so forth, it only focused on the plastic. Sorry.
Sorry, I don't mean to interrupt. But my understanding is based on your client's own testimony in describing, for example, the discarded plastic sheeting, that at that particular point in time was not designed waterproof a section of the cement work, and you agree to that. That's what he said.
Yeah, yeah, sorry, yeah.
And therefore, based on Bezdarek, as my colleague pointed out,
Yeah.
based on the decision, plastic sheeting is not a foreign substance under 1.7b.
Right.
So then, in advancing the notion of a 241-6 claim under 1.7d, court determined, as I understand it, it is not a foreign substance, so that particular regulation is inapplicable.
Right.
It then worked its way through all the other regulations. Was that pile your client described a work material pile? Was that, and he went through that kind of analysis. And
Right.
searching the record and applying the law to the fact, you're saying the court couldn't do what it did?
I am saying that respectfully, Your Honor, because the only item of debris that the court addressed in the order appealed from was the plastic under the 23-1.7 regulation. Yes, Bezdarek certainly says, I'm throwing myself on the dissent in that opinion, but I understand that's what Bezdarek says, that plastic sheeting, which in that case was intentionally placed as a protective coating over an escalator, and it's not the type of foreign substance. But in reaching this decision, the Supreme Court ignored the fact that there was also like a rock, a piece of chunk of rock or concrete or something of that nature.
Was that, do you contend that that was debris left over from
Yes.
the prior construction work, that was the debris that they
Yes,
had?
and there was a foreign substance of sand on top of the plastic. And actually,
So wasn't there some testimony that even if he had looked down, he might not have seen the plastic because all the sand was on top of it?
that's right. That's right, Your Honor. And his testimony, and there's really nothing that refutes his testimony. His testimony was that that was left over from the demolition of a sidewalk. That's clearly elsewhere. He's inside the terminal. There's no evidence whatsoever that either the plastic or any of those things were being used, generated by, or actually even related to any ongoing work by anyone in that area.
Counsel, he was also demolishing parts of Fordham Plaza, correct?
Elsewhere, they took down a
Elsewhere.
sidewalk.
So, I'm sorry, just to,
Yeah.
okay. And then, so what you're saying is that the debris that he actually slipped on came from another part of the work site?
That's right. He testified that he was dismantling a sidewalk bridge, and they were supposed to move it mechanically. The thing never showed up, so they had to move it manually. He's now 80 feet away from there, somewhat of a different area. It's not entirely clear from the testimony exactly what was what, but he described it specifically as a narrow passageway. That's not where he was dismantling the sidewalk bridge. It's elsewhere. And the debris that he described as being in that location, he recognized as remnants of a broken up and demolished concrete sidewalk that already had been replaced. And he said that the plastic remnant that was there was the kind of thing that they would use when it rained to cover newly poured cement on a sidewalk. It's not raining inside the building, I would respectfully submit. And so certainly at the very least, there are questions of fact.
As to whether 1.7E1 and 2 is implicated.
Yes. I would also argue for D because of the sand, which is a slipping hazard, and I call the court's attention, in fact, to
Did he slip or trip?
Pardon?
Did he slip or trip?
It's not entirely clear. It's probably a combination because there was sand on top of the plastic.
But he
There was
didn't
a rock
mention
there.
slipping on the sand.
He mentioned the sand as covering the plastic.
But did he mention slipping on the sand?
I don't know that he specifically was asked about the sand separately.
Couldn't see the plastic because of the sand,
That's
but
true.
he tripped because he
On the
stepped
rock.
on the rock.
Yeah, that's possible too. Your Honor, I would take any of those things to.
You just want a fact issue, right? Okay, thank you.
Good morning, Your Honors. May it please the court, Joseph Farini, on behalf of the defendant, City of New York. I wanted to quickly touch on a couple of points opposing counsel made. One, Your Honor, to your question, never, there's 3 depositions in this record, and never did plaintiff say that he slipped on wood or that he slipped on sand. It's not in this record. So to use that as a basis for avoiding summary judgment, you can't do that on this record. That did not happen. It's not in the record. Also, there was no testimony from plaintiff that this debris was old. Okay, the facts of record as to these construction materials are that starting 3 days before the accident, plaintiff started picking up debris in the area, and he's picking it up, and then bags of it, and that his foreman gives him the thumbs up, says, continue doing that. And then plaintiff testified, so I do that on my own every day, referring to the cleanup. Then in the next page, on his 15-minute break. So 2 days before the accident and 1 day before the accident, he's cleaning up in the area, okay? And so then what we know also from plaintiff is that this was occurring daily. Every day there was a chunk of the sidewalk getting torn up and becoming fresh debris.
So counsel, just to pivot, oh, go ahead.
One at a time.
Wasn't there in this record evidence that the city inspected the site daily?
No, there was not, Your Honor. At the end of the day, there was an engineer and people that were hired, okay, and that they would just do like a walkthrough at the end of the day.
Right, to determine whether the debris that you described was supposed to be picked up?
Not specific to the debris and whether that was to be picked up, no. And I would submit,
Counsel, I think this is a follow-up to Justice Shulman's question. Doesn't that provide notice for Labor Law 200 for a dangerous conditions theory under that section? As opposed to means and methods. We're not talking about means and methods for now. But wouldn't the city still be on the hook for a dangerous condition? And doesn't that provide notice that, you know, that the plaintiff gave you notice that, hey, this debris keeps popping up in the workplace here and I'm going to try to pick it up. But wasn't there notice to the city for sufficient for Labor Law 200 purposes?
no, Your Honor, and that's for two reasons. One, again, this was fresh work that was occurring daily, and we know from plaintiff, right, this injury happened in the afternoon, okay? So these materials, the most likely explanation on this record, are from the sidewalk that was churned up that day. So that's one. So if someone was looking at the end of the day, that wouldn't be applicable. Secondly, I would direct this court to Foley, right? And those kinds of cases that talk about how you don't need to have supervisory control, right? If you're looking and you have inspectors on site. And perhaps more importantly, you have plaintiff's testimony himself. He had been in that area cleaning, yet he came up upon this debris unexpected. It was fresh to him. And so the same thing would apply to the inspectors. If plaintiff is claiming that this was not within his sight and that it was not something that could be seen because of the sand on it, then that same argument would apply to the city. And that would go to the Gordon case. The Gordon case says that the condition must have been shown to have existed for a sufficient amount of time, and Gordon also said that the condition must be visible and apparent.
Well, didn't plaintiff testify that a couple of days before his accident, he had installed a new sidewalk, and so that some of this concrete was debris left over from a few days, or at least there's an issue of fact about that?
Your Honor, his testimony was that daily it was occurring. Every day there was a fresh chunk of the sidewalk getting torn up.
Well, I see that part of his testimony was that a couple of days before the accident, he had installed a new sidewalk. So I guess that meant they finished breaking it up and they installed it, and this was debris. Look, there may be some conflicts here, and it may be not 100% clear, but that was his testimony at one point, at least.
Your Honor, that is accurate that plaintiff testified that he did the jackhammering himself days earlier. And that every day fresh concrete was appearing in the area. But then we also have his testimony that he's doing the picking up. And so logically, he would see the debris there. And then when you also factor in that at 2 p.m., that day is when the accident happened, which would have been after the fresh construction work for that day, the evidence of record supports summary judgment.
So that pile of debris was something that occurred basically on a daily basis, because they created a pile and then had someone else come in and basically pick it up and haul it away. But workers complained that pile was being created and that there was debris in the area, which is what you say that the plaintiff on his own, took it upon his own to pick up some of that debris.
Just to clarify, not complaints to the city. The complaint was to Padilla, and that is what led to plaintiff, his complaints to Shura, led to plaintiff beginning to do his daily process during his afternoon break of picking it up.
But the city had a resident engineer there.
Not a city employee. They were a hired independent contractor.
Not a city employee?
Well, they had an engineer in charge. That the testimony was that he only appeared sporadically on site. That is the only city employee that was ever on the premises.
Was not there on a daily basis?
On a daily basis was an engineer that was hired through a staffing company as an independent contractor, CH2M, something along those lines. That's the company
that was a safety officer, right? That was there.
The safety officer also was Your Honor, provided by the CH2M as an independent contractor.
which was responsible for making sure that the passageway was safe and neat every day, correct?
That's not in the record. The
Well,
exact
I
duties
think
are
it's,
not in the record for the safety
I believe
officer.
it's in the record, in the appendix 509 and 51718, where it was inspected daily to ensure that it was safe and neat.
At
right?
the end
So,
of, at the
as
end of
my
the day,
colleague pointed out, that would suggest that they could be on constructive notice that the debris could be a potential trip hazard in the passageway if it wasn't picked up, right? I mean, it's an issue of fact. I mean, you're trying to say, based on the timeline, et cetera, that it's too new to constitute a trip hazard under the appropriate
again,
regulations.
again, Your Honor, I would point to Gordon, which says that the condition has to be visible. This condition, this plastic that was covered in sand, that plaintiff is saying, it was right on it and I couldn't see it. So then,
Well, he was carrying a beam, right?
yeah, but he also had
And
a clear path of vision
Carrying
in
a
front of him.
beam, and there was a ladder. I mean, there was a lot of stuff going on there. I mean,
His testimony was he could see clearly in front of him. And then, of course, I see my time is
Yeah,
up,
thank
but
you.
I would just note the changing story in our
Okay.
statement in the brief on that aspect. Thank you, Your Honors.
Your Honors, just very quickly, I respectfully submit that my colleague has engaged in a little bit of speculation about what's in the record about this supposed work that was imminently occurring, as he would have it, almost moments before the accident happened. I don't think there's any proof of that whatsoever. May that be an open question? It may or it may not, but the plaintiff's testimony is pretty clear that, he was complaining about this, about these conditions. It's also in the record. There's Mr. Charles's testimony. There's a safety plan. There are documents that talk about the continuous cleaning that was supposed to be taking place and was not taking place. And if you want to get some re-judgment under Gordon or under Labor Law 200, as the defendant, you have to show when you last inspected it so that you affirmatively disprove notice, which they clearly have not done here. Also, I think it's called CH2M. This is the staffing, the company that provided the staffing. The city retained some control. I understand that maybe or maybe not, that they were closely supervising what Padilla and plaintiff in particular was doing, but they were doing a lot of other things. They were supervising things at this site. And the staffing company was the city's agent. They were reporting to the city personnel at the site. So, notice to an agent is notice to the city in that type of a scenario. I would also just quickly point out, at page 238 of the record, the plaintiff says he tripped on the rock and the plastic. He was asked, further elaborate about that, but that is what he said. And also, just sort of interestingly, going back to the question about did he slip and trip, and there are some cases from this department, I know where sometimes both happen at the same time, sometimes both sections can apply to the same type of fall. At page 253, the plaintiff said that when this tripping over the rock and the plastic happened, he did a split. So he didn't say that he slipped, but I think it's sort of interesting. You don't normally just do a split, although I guess it's possible. But I think certainly there is support potentially for a finding to that effect.
Thank you.
Thank you very much.
Tuda Peroni Corp. versus City of New York.
Should it please the court, Stephen Rose Moreno of counsel to plaintiff appellant to Perini Corporation. The lower court in this matter held that the respondents have absolutely no obligation whatsoever to respond to the plaintiff appellant's delay claims.
Was there anything in the Article 11 of the contract, anything, any phrase, sentence that imposed a time-sensitive responsibility, unlike the duty on the plaintiff to be able to report delay claims within a certain period of time? Is there anything in this contract putting that duty on the city?
Yes, Your Honor, and that's section 11.9 in Article 11. 11.9 says any compensation provided to the contractor, and that's the plaintiff, in accordance with this Article 11, will be made pursuant to a claim filed with the comptroller. So that's a compensation provision. It says any compensation provided to the contractor. Who could provide compensation? Only the respondents could provide compensation. So that's an obligation on the respondents to pay for delay claims.
When you say respondent, which respondent are you talking about? The city of New York?
The City of New York, the DOT's project, and the comptroller has to decide the claim.
Right, because 11.9 speaks specifically to the controller.
That's right, and it says any compensation will be provided to them through a claim filed, but compensation has to be provided from the respondent, and that means the comptroller has to decide a claim. That's an affirmative obligation.
But that section, which I know you both disagree as to what you think that section means, doesn't say anything about the city having a specific time by which they have to respond to your complaints.
And Your Honor, when a specific time period for an obligation or to pay compensation is absent in a provision in a contract, New York law implies that it will be done within a reasonable amount of time. And the lower court decision completely ignores that. So if it doesn't say, for instance, that compensation will be provided in 30 days, which 11.9 does not state that, it's implied that it will be done within a reasonable amount of time. The question then becomes, what's a reasonable amount of time? We would submit compensation provisions. Typically, you would see something like 30 days if you look at the Prompt Pay Act. Certainly, waiting until substantial completion is not a reasonable amount of time because it's the project went
But don't other sections of the contract talk about you may have to wait till substantial completion?
They don't. So I think the other sections you may be referring to that were cited in the respondents' papers, possibly Article 44, which is the substantial completion payment rec article. I believe under that article, it says that the contractor will submit a list of any pending claims, but it doesn't say that claims have to stay pending until substantial completion.
So if you comply with your obligations under Article 11,
yes, Your Honor,
within the time period explaining the delay and all the paperwork, et cetera, et cetera.
Yes, Your Honor.
And as your position is as you can see, there's no specific time period for the city to respond to those claims, but you claim they should do so in a reasonable period of time. If they did not do so, there's nothing in this contract that barred you from coming to court as early as you could if you felt you needed to get justice and get that money sooner rather than wait till after substantial completion, which could be years later, correct?
Well, we would be skipping an exhaustion of contractual remedies because we have to make this through a claim through the comptroller. So if you look at Article 13, too, Article 13 says that delay claims, and it uses the word claim, which is in Section 11.9. It says delay claims will only be made as stated in 11.9. 11.9 says that claims could only be made to the comptroller. So that's not a claim to the court. That's a claim to the comptroller. So how can we just skip a contractual provision that says to make your claim to the comptroller and they're going to provide you compensation and just go right to court? It'd also be a waste of judicial resources. It would be contrary to the contractual interpretation principle not to render any provision meaningless. 11.9 would be wholly meaningless if we just submit a notice and then run to the courthouse.
The bottom line is your action here is that you want a declaratory judgment saying that the city had to respond to your submissions, your demands, right? And that the fact that they didn't respond is outside. I mean, is a breach of the contract, right? That you just want an answer to what you submitted.
We would like them to respond and decide the claims.
Right. So I'm looking at Article 11.9. It doesn't really say, it basically says you can't sue the controller, file an action with respect to the claim against the substantial completions within 6 months. This all talks about the controller. It doesn't limit your ability to go after the city separately outside of this. I mean, that's what I'm reading this. The restriction is only limited to the controller, not a restriction that's expanded to the city or the or Department of Transportation.
Yeah, so that's basically enabling a party to completely skip a claims provision or a compensation provision in a contract. Also, would we be aggrieved? There's case law out there that suggests that we would not be aggrieved until the comptroller denies the claim. We haven't had a claim denied yet, so is the claim ripe? Have we been aggrieved? There's case laws that suggest we're not, which would mean that they should decide to claim. That brings me to another point, and that's that.
You get that on rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Lauren O'Brien on behalf of the respondents. Supreme Court correctly found that Tudor Perini's argument is wholly unsupported by the text of the contract. The contract clearly imposes a set of obligations on Tudor Perini to document and notify the city of its.
They got to document all the claims, all the delays, and everything, and that's it. I mean, that's the requirement of the contract. There is no other requirement, or there's no mutual requirement on the city's part to respond to them, right? I mean,
Correct. It's clear from the face of the contract that there's no obligation on the part of the city.
What about your adversary's position that, well, if there's no specific time, you do have to respond in a reasonable amount of time?
So I think that I would just distinguish contracts that impose an obligation but don't set out a specific amount of time in which to carry out that obligation, and contracts that don't actually have that obligation at all.
In a way, they're arguing commercial reasonableness as well, and you have to impose a reasonable amount of time to respond. They're saying essentially that the city could make us finance this contract because they could make some radical change to the design, which would cost us a great deal of money, and we wouldn't even be able to see that money until years later after we completed the bridge. So how do you respond to the commercial reasonableness argument?
Sure. So in response to that, I'll just directly respond to their argument that they will not be able to bring a claim unless the city has responded to its notices or communications. There's absolutely nothing in the contract to support that they can't bring their claim.
That was my point about how this contract is a limitation on how you sue the controller, but there's no limitation on suing the city of New York.
And just to address,
I was going to ask you, what do they do in a situation like, as my colleague said, if you're going to put in all these new work order changes and astronomically increase the cost of this, are they left without any recourse? And you're
absolutely not,
suggesting
Your
no,
Honor.
they're not.
And just to address Section 11.9 specifically that was raised initially, that provision simply says that any compensation will be pursuant to a claim filed with the comptroller. In any claim against the city of New York, as this court well knows, a prerequisite to a claim is to file a notice of claim with the comptroller. So all this party needs to do is file their claim with the comptroller, wait the requisite 30 days. If the comptroller hasn't responded, that in no way bars them from bringing the claims that they want to bring against the city of New York.
But that's different from them asking in this action to compel you to respond.
Right, exactly. And I would just note that the relief that they're seeking, they're basically asking this court to declare that the city is required to respond to every delay notice that it receives in under every construction contract.
If we were to agree with that, we'd
be
opening up a real big can of worms for the city of New York.
Absolutely, Your Honor. It would be imposing a huge burden on the city based on something there's really no textual basis for it at all in the contract. And just to quickly, so for that reason, our argument is that public policy actually favors the city's interpretation of the contract, which is the one that is supported by the contract's plain meaning as well. And just to quickly address their argument based on the covenant of good faith and fair dealing, there's no basis to invoke that covenant when the meaning of the contract is clear, which it is here. And again, the entire basis for their argument based on that covenant is this idea that there's somehow a loophole, they call it, where they aren't able to bring their claims because the city hasn't responded to their notices. And again, as explained,
basically, they're arguing that they have to bear all the upfront costs. And like I pointed out, 11.9 doesn't restrict them from, there's nothing in the contract that says you can't sue the city directly.
Correct. That's exactly right. And again, there's no reason why this contractor in particular wouldn't be aware of that. This is a repeat player in contracts with the city. And this contractor represented that it examined the entire contract before submitting its bid. And that if it represented that if it won, if its bid was selected, that it would agree to every term in the contract. So it was well aware of the terms of the contract, and it knew that delays were a possibility. That is set out clearly in the contract. So there's really no, again, as I started with, there's no basis in the contract for their argument.
Okay.
Unless your honors have any further questions, we would ask this court to affirm.
Thank you.
Yes, Your Honors, just if I may respond to a few points. We're not asking the DOT to respond to every single notice. We're asking them to
Well,
decide.
no, but if we agree with your argument, we would be essentially setting precedent, or at least opening up the avenue where that will happen going forward, because everybody's going to say, look at this decision. It says you got to have to give us a response for every single delay claim that we make, even though it's not said in the, even though the contract says you can't do that.
Well,
that's what's going to happen, counsel.
Your Honor, I think the adverse consequence of a decision from the First Department here would be affirming the lower court, because then you would have a wide, broad decision that would affect all contract law in the state.
Counsel, but what do you say to her response that you're not barred from suing the city of New York? You're just barred under this agreement here to go after the controller. You can file a notice of claim, you can go through the whole process, and you can commence a plenary action for the city. You don't have to, in other words, the argument I see from you're making is that the city is making you bear the upfront costs for the project without payment. And her argument or her response is, they could sue the city directly. What's your response to that? You saying you can't do that?
It's a waste of judicial resources. Certainly, if the court's
no,
going to hold that, then we're going to.
How many
there's
appeals
gonna
that
be
we
more
hear a day
litigation.
that's going to have waste judicial resources? Come on. That's not a good answer.
And 11.9 is a new provision in the DOT contract.
You didn't answer my question. The question is, when I'm hearing your argument about why are we having to bear the upfront cost, that shouldn't be. They should be paying us if there's something that happens in a change order. And the response was, Judge, they could sue the city directly, file a notice of claim, go through the whole process. Can you or can you not do that?
My understanding is we could not, because we're skipping the contractual step of making a claim to the comptroller.
Where in the contract does it say you cannot sue the city?
The contract says that we could only be paid compensation through a claim to the comptroller. So that indicates that we have to take that step. The broader implication of this case would affect all contract law in the state, and that would be that any contract that does not have a specific time provision for an obligation or for compensation, that would mean that the parties never has to perform.
Well, no, counsel, it doesn't have, it's not that it doesn't have a time sensitive in terms of response. It doesn't have any response at all. So you're asking from case law saying that, well, if there's no response at all, there's no response time at all input in the contract, case law says that we have to impose a reasonable time. I find that very hard to accept, because a contract's a contract. That would be for us to write a condition into a contract, to now impose on the other side saying, well, no, you know what, it's not in the contract, but by the way, you have to now respond to this claim.
And I don't believe it would be writing a condition into the contract, because the contract says that's how the compensation will be made. So that's essentially just a compensation provision, and it's stating how we have to go about being paid there.
Okay, thank you.
Thank you.
Patrick Tolino versus Ciazzi. Justice Mendez is recused from this matter. Sir, you're up.
Oh, just gonna get a sip of water real quick. Thank you for hearing me.
Can you identify yourself, please?
Oh, I'm John Peter Tolino, the plaintiff appellant in this case.
Okay.
And I guess I'll start off by saying that the courts are here not to guarantee you justice, but to give you a shot at justice. And a lot of times there are disgruntled plaintiffs upset that they didn't win their case and things like that, and feel that their attorneys didn't do the right thing and whatnot. But meanwhile, if their attorneys did conduct a viable thing that just didn't work out, then that's just the way it goes. I mean, that's just life. But my situation, I believe, is different. I got hurt on my job in the building trades. I was a unionized electrician, local union number 3, while working in the subway, the 2nd Avenue subway project. And at first, I wasn't interested in suing. but my union rep for workers' comp, based on his advice, he recommended that I do so, but it was beyond the 90-day time limit to file a notice of claim. However, we hired the defendants to see if we can, to have a meeting to see what was feasible, and he claimed that he could possibly win a petition under, I think, 50E to obtain a filing for a late notice of claim, which he successfully did through very good lawyering. He was very good. So we were so far good to go with the defendants, that being the City of New York City Transit, MTA, and New York City Transit Construction were the first defendants. The first three required a notice of claim. The fourth one did not. So time went on, and then I was on workers' compensation at the same time. I had filled out in the beginning when I got hurt, because there's a very brief time limit for you to fill out what's called the workers' comp C3 form, and to apply for workers' compensation. And I did so while in immense pain. I had a broken shoulder bone, a rotator cuff tear, a slap tear, a labrum tear, and a concussion to my head. But I still had I didn't have a workers' comp attorney yet. Time was expiring. I had to get that form in. There was a time limit. I answered it to the best of my ability, which it states in the bottom of the form. It doesn't state that you're answering such under oath, but you're answering such to the best of your ability. And apparently I had a concussion at the time, which was later discovered to a neurologist. And there were numerous errors made on the form. I put the date that I started with my company as to being the date of the injury, which was completely wrong. So I made some inadvertent errors on a mistake, but there was no intention whatsoever to misrepresent anything. So later on, Mr. Ciacci notified me that we were going to be deposed on basis of what we all know was called a 50H hearing. The personal injury defendants were Wilson, Elser, Moskowitz, Edelman, and Dicker on 42nd Street. So we met there before the deposition. We spoke at the Starbucks next door, and Mr. Ciacci advised me. He said, here's the thing you have to know what to do. When he asks you a question, you have to answer pretty much all the questions. But when he asks a question, hesitate. Don't rush an answer. Wait for me to possibly object, because if he asks anything that's privileged and such, I'm going to object to it. If I don't object to the question, then you answer, and only then do you answer. So at that point, we went up, we began the deposition. I was introduced to an attorney named Adam Brian Rosen, who's an attorney for Wilson, Elser, Moskowitz, Edelman, and Dicker.
So I'm going to have to stop you. The red light's on.
Oh.
She has an opportunity to respond to what you've said, and then you'll have an opportunity to respond to what she says.
Go ahead. Yeah,
Okay?
sure.
All right, thank you.
I sit down now.
Yeah.
Good afternoon. Cheryl Corman for the defendants. We have an amended complaint here that states certain causes of action. The amended complaint was properly dismissed. There's nothing here, no facts pled, that indicate that anything that was done by my clients had any effect on the termination of these workers' compensation benefits. The workers' compensation judge had a hearing and heard all of the excuses as to why the C3 form was filled out wrong. And the court rejected all of those reasons. And in doing so, the court specifically said, I'm citing the misrepresentation on the C3 form. I'm citing the misrepresentation to the IME doctor. I'm rejecting.
So this lawsuit, so what I'm hearing is this lawsuit is arising out of the workers' compensation denial?
Exactly, Your Honor, and which was then confirmed by the board. The workers' compensation judge made specific findings as to plaintiff's credibility. That has nothing to do with anything that was done by the defendants.
But wasn't one of the issues here the litigation funding, and somehow you bear some responsibility for the for what they had to pay for what
we could talk about the litigation funding,
plaintiff had
sure.
to pay back after he got almost $1 million from your firm in mediating a settlement, correct?
Well, I believe
it was
$900,000. It does come out in the record later on, but that's supposed to be confidential.
I meant later, but the point
yes.
is in the course of this litigation,
There was a litigation funding agreement,
Where
which
he
was,
borrowed, where he got almost $90,000.
we got about $180,000.
Okay,
There were
and
4
my understanding is if there was no successful mediation or settlement or no jury verdict, he would not have to pay back a penny.
Exactly, Your Honor. It was non-recourse. There was not, there was no, it wasn't a guaranteed repayment to the funding company. So pursuant to the cash for cases coming out of this department, it's not considered a usury loan. I just want to quickly touch on the other causes of action. There's certainly nothing that would support a claim for fraud, no material misrepresentation or intent for reliance or actual reliance in connection with any of the allegations. The fact that an authorization was given to the municipal defendant's attorney to access the Workers' Compensation Board, that's absolutely appropriate. Even a claim of a forgery, which of course my clients deny, still don't meet the elements of a claim for fraud. Similarly, a claim for conversion doesn't exist here. There was no exercise of any possessory rights of anything that belonged to the plaintiff. And again, it was also appropriate not to order a hearing on the issue of how my client obtained a copy of the Workers' Compensation Board. It was clear that he was still representing the plaintiff, although still in the personal injury action, and in fact was specifically discussed when you look at that purported stipulation that was entered into. They clearly discussed the content of the Workers' Compensation Board finding and the fact that it might be detrimental to a subsequent personal injury case should he not want to proceed with the settlement. Unless the court has any questions, I'll rest on my brief.
Okay, thank you.
Thank you very much.
Folks, I want to state that my case was not about workers' compensation. It was about my personal injury case. I just didn't get to the point quickly. It's difficult to do so.
You entered into they got a settlement in your personal injury action.
Ma'am, I was
against the
basically
city.
what it was.
Personal injury action.
Ma'am, I was
against the
basically
city.
what it was a mediation that was ambiguous. We did not know what was going to be taken out. It's not what you earn; it's what you keep. There was nothing in that mediation that day that stated what we were going to owe.
To who? The funding company?
Not just the funding company, the workers' comp, what we're going to workers' comp for medical bills, Mr. Siachi's contingency fee, and he never, this funding situation, we never saw the contract after he was terminated. It was we who terminated him. He sent us a stipulation attempt trying to get us to, because I had second thoughts about the mediation because it didn't state enough. It was ambiguous. It didn't state who do we have to pay back. What is this thing you got us involved in? He never put that in the mediation. You'll see that. Everything is in both briefs.
Okay, thank you.
Which he deliberately left everything out.
Thank you, Count. Thank you, sir.
You're welcome, sir. I wouldn't be here otherwise.
All right. Oh, you're done. Oh, you have to, someone's coming next, so.
Oh,
yeah.
Okay, folks. I didn't waste your judicial time.
Thank
We
you.
said earlier. Have a nice day.
Citigroup Global versus SCIP Capital. Okay, counsel.
Thank you, Judge. Good afternoon. James M. Catterson, along with Danielle Stefanucci from Pillsbury, Winthrop, Shaw, Pittman, along with Dewey, Pegno, and Kramarski representing Citibank. This is really it's one of those rare appeals which got simpler rather than harder the more I worked on it. It is a very simple and yet very important case. The basic rules of contract interpretation and consequential damages have been in effect in this department for the better part of a century. The wide-ranging impact on financial institutions in what most consider to be the financial capital of the world, however, are important in this case. What were Citi's responsibilities under this agreement? Record page 158, 159, Citi had to use its best efforts to offer Silver Fern deals to club members that Citi identified. What is the club? High net worth individuals that were clients of Citibank. There were 39 of them. They had to meet certain requirements. They were all very, very wealthy. Citi had to identify the individuals. Citi had to communicate with the club members. Citi had to had to secure the required documentation, it's 146. But most importantly, Citi could provide no opinion or recommendation whatsoever on each individual investment. That's on pages 320 and 321 of the record. Silver Fern's own brief says that Citi was not allowed to market or promote the products in any way. The members of the group had to conduct their own independent investigation, review, and analysis of every single transaction. They had to ensure, not Citi, they had to ensure that they received from Silver Fern all the information they believed necessary to make these investments. And again, these are sophisticated, very wealthy investors. The decisions had to be made solely, and this is on page 233 of the record, solely on the members' independent due diligence, not Citi's work. And any questions about the deals had to be directed directly to Silver Fern.
Well, Counsel.
Yes, sir.
Go ahead.
I was going to say that, you know, the point of the matter is that there's an April 11, 2016 letter the city sent.
Yes, Judge.
It sort of ruffled some feathers, right? Because that's, in a sense, we all know, I mean, Citi's name is what makes a deal go, right? I mean, and then Citi all of a sudden sends this letter saying, accepts no responsibility or liability for any additional products, and any decision you make to invest in any additional product is taken at your risk. Pretty much says to an investor, you know what, you're on your own. We're not backing this deal anymore. So how does that tie into what you're...
I disagree, Judge.
Okay.
First of all, the deal as we know it, in other words, the successive investment renewals of the investment group started to not bear fruit long before the 2016 letter. But why did the 2016 letter come about? Because Silver Fern elected to propose an investment vehicle, the RSMA, to several members of the group outside of Citibank's participation. They approached several investors.
Which they were allowed to do, of course.
I'm sorry, Judge?
They were allowed to do that.
Absolutely, Judge. And so what happened was, after they proposed this other vehicle to members of the group, Citibank received, it's all in our brief, Citibank received communication saying, what is this? The 2016 letter is a direct response to that, saying, if you have any questions about the RSMA vehicle, you need to talk to Silver Fern. This is not, as O. Peter Sherwood absolutely discovered, this is not pejorative of the funding group at all. In fact, it says we still fully stand behind it. There would have been no reason for us to disparage the relationship in 2016. But more importantly, on this record, there is not a single citation in my adversary's brief to any communication from any investor that Citi's input at any way affected the decision to invest. Not one.
That product that Silver Fern put out, was that pursuant to the contract that it had with the what is it, DSA?
No, Judge.
It was not pursuant to the contract.
No,
It
not
was
at all.
Something totally outside the contract.
Yes. It was not one of the group investments that was put forward to the group through Citibank.
But wasn't, the letter did go on to say that Citi accepts no responsibility or liability for any of these products, and any decision you, meaning the investors, members of the club, make to invest in any additional product is taken at your risk. So isn't there at least an allegation that this did affect some of the investors? You say there was nothing in there, but the email back and forth seemed to calm down. There seemed to be some kind of noticeable change in relationships activity after the sending of that letter. I mean, I read some of that.
I could answer it, Judge.
Is it okay, Judge Owen?
Oh, sure.
Yes.
Thank you very
Please.
much.
Light's not for us. I mean, not for you.
I wouldn't presume, Judge. You have to remember, Judge, that our obligation, our only obligation writ large under this agreement, is to use our best efforts to offer the products that we agreed with Silver Fern we would offer. That's our only obligation.
So couldn't there be a question that sort of saying, do what you want, don't call us, might not be falling to best efforts?
Except, well, no, Judge. There's no dispute on this record, and Silver Fern can't get up and argue that we didn't offer every single product to all 39 investors over the entire lifespan of this agreement. In fact, they say exactly that in their brief. We did offer every single product to every single member of the group for the lifespan of this agreement. That's not in dispute. It's simply not in dispute. And so the whether or not we did say that you have to make your own independent decisions. They were contractually obligated to do exactly that. Every member was contractually obligated to make only their own decisions. With regard to the club investments, why would we tell them anything else for the non-club investments that Silver Fern put forward? Thank you, Judge.
Thank you, counsel.
Good afternoon, excuse me. Good afternoon, Your Honors. Robert Smith for the respondents' appellants. With me is Lance Bowman from my firm, Friedman, Kaplan, Seiler, Edelman, and Robbins. I think I'd want to begin by some facts that I think my adversary didn't mention, and particularly the April 11 letter, which the court referred to, and what happened exactly 1 week before the April 11 letter.
The March 28th letter, right?
I'm talking about the April 4 email.
Oh, the
which
emails.
is at it's at some page of the record, and I have it written down here somewhere. But the the prelude to that was that we had proposed a slightly different product from the one that was the subject of the agreement. It's not totally correct to say that it was wholly outside the agreement, because in fact they were entitled to get fees on it. There's a provision in the contract that says that they can earn fees on products that are not of the kind described in the agreement. That's 4G. And we went to them, my client went to them and said, here's this new product we want to offer. This is in 2014, we went to them, said, here's a new product we want to offer. Well, of course, you'll get your fees. What do you think about it? And the first reaction is, looks pretty good, but it has to go to a committee. We don't know to this day where it ever went to that committee. Well, it certainly never came out. But 2014, nothing happens. 2015, nothing happens. It's March 2016. Nothing has happened. And we go to city and we say, you know, we're entitled to do this on our own. We're going to do it on our own. And they didn't, to us, they reacted in a perfectly appropriate way, but the internal documents show that city bankers were going berserk. And that's the April 4 email, and I do have the record page 2179. Just so you know, this is one city employee writing to another. Just so you know, APAC, that's Asia Pacific Bankers, are not one bit happy about this. People have made comments like they need to be put in line. The relationship needs to be severed. Did they find a loophole in our agreements? How are we protecting our clients, et cetera, et cetera? It's not entirely clear to me why there was all this angst, but I think it can be deduced from the record for reasons, at least partly deduced, for reasons we have never figured out and city has never disclosed. They decided they didn't want to take their fees from this deal, and they refused the fees. And presumably that was done at a higher level. The bankers were furious because they weren't going to make money, and they couldn't be furious at their bosses, so they got furious at us. And that's what happened. And the April 11 letter, certainly on summary judgment, where I'm opposing summary judgment, can be read as an implementation of what was said in that email. It can be read to say, we are going to bring them into line, and we're going to, and the relationship, well, if it can't be severed because it can't legally, it can be trashed. And that is what this letter.
You're saying that this letter trashes the relationship when the letter simply says exactly what the parties had agreed to, that the investors could do their own due diligence, and that simply Citibank, this is something that is outside the contract.
I don't think it's 100% outside the contract, Your Honor, and it's not, and there are ways to say, first of all, I don't really see why they had to say it at all, but you don't have to volunteer to your clients, by the way, you have nothing to do with this unless somebody says you have. But if you are going to do it, there's an appropriate way to do it. You could consult your partner. You can say, look, we've got to disclose something. Here's the letter we want to send. What do you think? Instead, it's written in a way that is obviously designed, I think, to destroy the relationship. And we have an expert there who gave the same opinion, and certainly on summary judgment, you can draw that inference.
So when is it exactly that you stopped making payments to Citibank? Because they're suing for a certain amount of unpaid fees.
I think the answer is 2018, Judge, but I'm shaky on that. Do you know the date? But the last payment was in 2017, Your Honor.
So during this period after the April 11th letter and whatever, there were still payments being made to Citibank?
I believe so, yes, Judge. And of course, we didn't know that they'd sent the letter. That's another kind of shocking aspect. That's just not the way you fulfill a best efforts obligation. You can argue a lot about what best efforts means, but it doesn't mean you stab your partner in the back. It doesn't mean you write a derogatory letter.
Counsel, you also point, I believe, to the behavior of the plaintiff after the letter was sent, so that there were fewer contacts, you say, between personnel at Citigroup Global and the various club members. Yeah. But then the response to that by Citigroup is, well, by that time the relationships had been established. So there was a one-to-one relationship between Silver Fern and these people, high net worth individuals, and so they didn't need us to write constant emails.
Well, that Judge, is an issue of fact. We have an expert who says not so. Says this was that it was their duty to keep in frequent contact, and they'd and it's funny how they got the relationship just established enough so that they could drop off the emails like that, like dropping off a cliff in early April of 2016, just about the time they're sending the letter. A finder of fact could not be so indulgent about what was really going on. And of course, not by coincidence, not only did the email communication tank, the club tanked. The business that had been going very well suddenly fell apart. And all of our clients are saying to us, gee, I'm sorry, I'm committed somewhere else. I'm busy this weekend. That's the problem we ran into. I think I'll. Thank you. Sorry.
Counsel, you also have a cross appeal. You ran out of time, but briefly talk about your consequential damages so that counsel can respond to that.
Yes, sure. I think the test for consequential damages is whether it's within the contemplation of the parties at the time of contract. To a very large extent, the leading cases are Kenford and Ashland. Ashland makes clear that to a very large extent it's an issue of foreseeability, and foreseeability isn't even challenged here. But it's also an issue of how closely related the transaction was to the contract, how much in view it was at the time.
Where, Mr. Smith, where in the contract does it contemplate future clubs?
Oh, there's I believe there's a specific provision in the contract that says that if there are any other I think it's investment partnership deals, they get fees. There's also in the negotiations leading up to the contract, there's an email that says, how would you feel about giving us a right of first refusal on future clubs? In the correspondence right after the contract.
But wouldn't the consequential damages that you're seeking here be extremely speculative?
No, Your Honor, I don't think so. We have certainly not so speculative that it's very hard to make that decision on summary judgment. We've got an expert who gave a very highly qualified expert who gave an excellent report, who explained, he made assumptions. All experts make assumptions, but the assumptions aren't disproved on this record. In fact, they don't even try to disprove them. They just say, oh, there are a lot of assumptions. Well, of course there are a lot of assumptions there. There are always a lot of assumptions.
They went out till 2036, didn't they?
In
his report?
Look, the finder of fact could certainly decide that at a certain point he or she, or this is Justice Chan would be the finder of fact, would say, I'm sorry, I don't buy this level of damages. There are a lot of stuff that doesn't go out to 2036. There's something called Fund 3, which was I think a successor club, which was very much underway at the time of the breach, and which was doing extremely well until the breach of contract came along. So to say, even if your honors think, okay, I'm not going to swallow going into the 2030s, that does not justify dismissing all the consequential damages. It's not a summary judgment decision.
Thank you.
Thanks.
In response, a few points. If you read Silver Fern's brief, you come away with the overwhelming impression that we had the obligation and responsibility to both market and promote their individual investment vehicles. We didn't. In fact, the exact opposite is true. We were prohibited from doing it. How could we be held liable on the 2016 letter for reminding every investor of their own obligations under the agreements that I recited when I started today? Justice Long, 2 appeals back, you said a contract is a contract.
Okay.
You did. That's this case. Our only obligation under this contract was to use reasonable efforts to send each investment vehicle to each member.
So is reasonable efforts something that's a question of fact? I mean, what are reasonable efforts? You know, reasonableness is always something that's sort of...
Sure, Judge. In some cases, yes. In some cases, yes. Except this court has been clear since at least 2008. It's the Brown case, and we cite it and quote it, that it's a best efforts or reasonable efforts clause is only enforceable when accompanied by an objective criteria in the clause itself against which the parties' efforts can be measured. In other words, there has to be some measure of what best efforts constitute. It can't be, in this case, that this court is going to hold that a distributor of investment products could face titanic to 2036 liability if it fails to ensure a particular level of email traffic, a metric nowhere contained in this agreement. Let me just deal with the expert for just a second. The expert's report violates every rule that this court has ever enunciated on experts. 1, and I commend it to your reading when you need some entertainment value, on pages 23, 32, and 33 of the record. It's the deposition of the expert. And he is asked repeatedly, what authority do you cite for your opinions? What authority? And he says repeatedly, myself, I'm the expert. This court has always rejected that. He talks about a typical placement agent arrangement for an investment manager in an ordinary private offering, not disagreement. He doesn't talk about disagreement. He talks about the number of emails that 5 bankers out of the dozens and dozens of bankers over a handful of the investment vehicles. What does that mean? He's done an incomplete quantitative analysis that's substituting, if I could just finish this out, that's substituting for a qualitative analysis. There's nothing in that expert's report that would ever see the light of day on the witness stand. And I would suggest it can't be relied on to create an issue of fact about something they admit, that we offered every investment vehicle to every investor. If consequential damages, if I could.
I was going to say, you...
Thank you very much.
No, briefly, you want to respond to the consequential... I'll let you give some time on the consequential damages.
Thank you. I know you all know Kenford 1 and 2. It's the Buffalo Bills domed stadium that never got built. Kenford 1 it was actually a much better case for the plaintiff than this case. In Kenford 1, the fight was over a management agreement for the stadium that was never built. And so the person who was going to manage the stadium that was never built sued the county of Erie and said, this was consequential damages. You knew I was going to do this. And that management agreement was appended to our contract. Court said, no. Court said the common sense rule applied to consider is what the parties would have concluded had they considered the subject. In other words, at the time, did they say, okay, if it goes wrong, we'll pay the management fees all the way out. Kenford 2 was even more attenuated. That was the property that the company bought adjacent to the stadium that was never built, and the court rejected that as well. I bring this up because my distinguished colleague wrote a dissent on a consequential damages case where the court in by economy market, we cited in our brief, allowed consequential damages for a business interruption policy beyond the limits of the policy for the bad faith refusal to settle the claim. What the dissent wrote is interesting. The dissent wrote, under Kenford, the premise of consequential damages awards is that they effectuate the party's presumed intentions at the time of contracting. The common sense rule to apply is to consider what the parties would have concluded had they considered the subject. This is how he finished out the dissent, and it couldn't be more apt for this case. Can anyone seriously believe that the parties in these cases would, if they had considered the subject, have contracted for the results reached here? Imagine the dialogue. Applicant for insurance. Suppose you refuse in bad faith to pay a claim. Will you agree to be
This was
liable?
the dissent, right? So that's not the precedent.
It's not the
I
precedent,
wouldn't go on at
Judge.
such length. I mean,
I guess it's because.
rhetorically, I understand what you're doing, but
Judge, it's not even rhetoric, because the dissent says that Kenford applies. I think everybody on the bench is going to say Kenford 1 and 2 applies. The point is there anybody who could possibly conceive that Citibank said when they inked this agreement, oh yeah, if it goes wrong, we'll pay their investment vehicle profits for the next 20 years? I would suggest the answer is plainly, as in this dissent, no. Thank you for your time.
thank you.
I'm delighted to hear that my dissent is now the law. It was one of my favorite dissents. But in fact, the majority in that decision is the law, and it did allow consequential damages, which I think are a much greater stretch than anything that's that my client is looking for here. My adversary has opened so much area for comment. I hope I can get to everything. I'm going to let me start with the question whether there's any reason to believe that the parties would have agreed to pay consequential damages. In this case, I've already suggested some, but there's another one that I didn't mention, and I think it's very much worth considering in this case, the omission of a consequential damages disclaimer. That in itself, of course, is common and would not resolve the case in my favor, although it might be enough to defeat summary judgment. But here we have a case in which every other contract related to this deal has such a disclaimer. And it's certainly a possible inference.
Counsel, it seems to me the autonomy of the club members to decide whether or not they're going to participate basically just blows that up.
Oh, I don't agree at all, Your Honor. The club members, city's clients, all signed an agreement saying we're going to make our own decisions. We're not going to rely on city. All right, suppose I have a contract with Mr. Bowman. Mr. Bowman says I'm going to make all my decisions. I'm going to rely on city. Then I go to Mr. Bowman and say, you know, that man Catterson over there, don't deal with him. He's no good. And Mr. Bowman turns down a deal with Mr. Catterson. Are you saying Catterson can't sue me for interfering with the deal because Bowman signed a contract saying he wouldn't rely on my advice?
I need more facts. Also, I don't have to answer the questions.
Okay, sorry.
But is that what the letter says?
It's purely rhetorical, Your Honor.
Is that what the letter says? Don't rely on Silver Fern? Or does it simply say, this is outside of our contract, you can do your investment, but you're on your own?
Your Honor, I don't think you can, I mean, obviously people can read it different ways, and if people can read it different ways, no one gets summary judgment. But certainly the way I read it, I do not see how you can read that contract and not say, oh, this relationship is in trouble.
Well, if you're saying that the members of the club could read that April 11th letter, and I think there was also another letter shortly thereafter, and say, wow, it seems like everything's not so
The
good.
bloom is off this rose. City is not happy with Silver Fern, which was sure true because there are the internal documents showing they were berserk. And I don't see how you can fail to get that message. But if you can,
or at least there's an issue of fact as to
at least there's an issue of fact. Absolutely.
Okay, thank you, thank you.
Okay.
All right, thank you, counsel.
Thank you.
Functional Life versus Aspiring Munchkins. Okay.
Good afternoon, Your Honors. May it please the court. My name's Jerry Kraus, and I represent the plaintiffs in this matter. The lower court did not even address the key admissions upon which our motion was premised, which demonstrated conclusively that each of the elements of the only thing we have to prove, which is that the defendants used my client's resources, confidential information, property, or facilities in preparation of creating their competing business. That's all we need to show.
Counsel, you're saying that any use, like a single email, would be enough?
I'm sorry?
What's the threshold? Are you saying that one email would be enough if it was done during company time on a company account? Would that be sufficient?
This has nothing to do with just one email. The key.
What is the threshold then? How much involvement of company resources of functionals?
Well, let me explain to you what company resources they use and why they are well above whatever any threshold is. And what they did, the key requirement to obtain the contract was to contracted with providers who could provide all of the different services. Very hard to find these providers. There were all kinds of special services. It was speech therapy and occupational therapy and special education and about 16 others. And they had to speak.
Counsel, please, if I'm asking a question, you have to stop talking. Just stopping there. They were independent contractors, right? They were not required to work only for Functional Life. Is that correct?
Whether or not they were only...
Is that correct, counsel?
That is correct for some of them, but the employees were. They were not required only to work for FLA, but the obligation was on the person who was running FLA for FLA. She had an obligation not to go to those people and solicit them. They admitted that. The admissions that we're relying on is that they admitted that my client's most important asset and most valuable asset was its providers. They admitted that the provider's identity and qualifications is highly confidential information and they couldn't disclose it to anybody. They admitted that they only knew of the FLA providers based upon their work at FLA. They admitted that they could not use the names or the information of FLA's providers for their own benefit or in competition with FLA, irrespective of whether they signed any document. And they admitted that they could not solicit, recruit, or hire those providers to come to work for them, irrespective of any agreements. And they admitted that they did so. Their application showed that 6 of the 7 required people that they needed in order to get this contract were those that were employed by my client, that the chief defendant only knew because her job was to hire them, was to protect them, and to keep them for my client. So instead of, so this isn't about one email. This is about cherry picking a group of providers that are not available publicly. If they had wanted to compete legitimately, they could have. They could have gone out and created a new company. They could have done what my client did, advertise, create programs to find these people, but they can't just go into my client's confidential information and say, oh, I'd like to have this business. I need a bunch of employees to do that. And to have the person whose job it is, who supervises those employees, while she's working for my client, to surreptitiously go to them and say, hey, I want to create a new company. Will you come work for me? And she admitted that she did that. They signed contracts with our independent contractor. Chute signed a contract on the day she got this agreement with one of my client's providers that was immediately effective for her to work for another company. And so this isn't about one email. The key resource they used were the providers, and that was an extremely confidential resource, and it's a resource that it took my client 20 years to develop these people. You can't just go out and find them. They only found these people, And and it was because they had these people there that within a 2-month period, they were able to to obtain a very valuable contract from which they made $3.5 million from, not based on their own work.
Excuse me, I wanted to ask a question.
I'm sorry.
I know you're passionate about your case. My question is, so these people were working there, whatever agreements they may have signed, a lot of those were no longer in effect, but that doesn't mean they don't have any obligations, I understand.
I'm sorry, I didn't understand what you
I said, I understand that the people may have signed agreements earlier along that may not be in effect anymore. That isn't the end-all or be-all. But they were working there for many years. They decided they wanted to go out maybe and open up their own company. You're saying they have to forget every contact or every person they ever met, and they had to, I mean, they knew the names of these people because they had been working. They couldn't say, I'm going to open a new company, would you want to work with us too?
No, they can't, because they admitted on deposition that they understood that they had an obligation. Every single one of them said, and I put the quotes in the brief, we cannot solicit any of the people that we learned about, the providers we learned about at FLA, for our own benefit. They admitted that. They knew that that was their obligation. They knew what it took to get to create the stable of employees that it was to do this. Now, that doesn't mean if they were able to qualify and able to open their own business, that these people could have come to them at some point and said, hey, I'd like to work with you. But that's not what they did. And they admitted in haec verba, we are not allowed to solicit these people. We are not allowed to use them for our own benefit. Those are their admissions. That's all we need for summary judgment.
Thank you. You have rebuttal time.
May it please the court, I'm Andrea Fisher. I represent the respondents, aspiring Munchkins, Mia Chu, Elaine Lowe, and Ki Guo in this matter.
So I want to ask you, did your clients at the deposition admit all those things that they did as your adversary has indicated? I didn't think so, but maybe I missed it.
They did not. What they did admit is that FLA, or Functional Life, considered its list of providers confidential. They never said that is where they got the names of the list of providers. In fact, Elaine Chow was the person responsible for getting other independent contractors who she had come across in her practice as a physical therapist. She's the one who came up with those names. Ki Guo testified she didn't even know some of the names. Ms. Sheng, the owner of Functional Life, or the director of Functional Life, testified that her confidential list of providers contained over 1,000 names. Okay, 7 of those names were listed in my client's application. Only 1 of them ever came to work for my client as an independent contractor on a per diem basis.
Yeah, but the plaintiff makes the point that you got the license from, or whatever it was, from the state of New York by using those names. So they were value to you, and they took some value away from the plaintiff.
I don't think they took value away from the plaintiff. There are over 100 EI agencies in New York. My opponent very passionately claims that this was a very valuable resource, except she had over 1,000 names. These were 7 of those names. So, and I understand that some of the names were names of people who had worked for Functional Life. And I understand that's going to be an issue of fact for the trier of fact to decide whether these names were the names that caused New York State to approve the initial application. It was not the template once they actually started working, because there were 2 more approvals from New York City that they needed. So they got
Can I return to the admissions for a minute? Let's talk about Ms. Guo's admission. So I'm going to quote something to you. She said, quote, "We're not supposed to use the identity of the therapist for our own purposes in competition with FLA." Isn't that somewhat of an admission that is damning?
I don't think so, Your Honor, because again, there were thousands of names. I'm sorry, over 1,000 names. I don't remember how many thousand, and we never saw that database. Ms. Guo wasn't even the one who approached people. It was Ms. Chow, and She had no access to any of this. She never even worked in the office.
So Ms. Guo was speaking hypothetically in
Yes,
saying that?
yes, Your Honor, she was. And I think that all of these questions that were asked by Ms. Kraus at the 4 days she took Ms. Chu's deposition and the 2 days she took Ms. Chow's deposition and the 2 days that she took Ms. Guo's deposition asked if FLA considered its list of providers important and confidential. And the answer to that from my clients would, of course, be yes. But that doesn't mean that that's how they got the names of those providers. But that is a question of fact.
Is there a list of these providers that is publicly available?
No, of
Not
providers?
necessarily the 1,000 people that FLA had on this list, but is there a public place where you can go and get list of providers?
I am not sure, Your Honor. What I do know is what my clients did was they posted job openings in Indeed once they actually started practicing, and that is how they got their list. That is how they got the people who have actually performed services for them as independent contractors. But I'm sorry, I don't know the answer to
That's why a lot
that.
of these providers are independent contractors. They
Correct.
don't want to be tied down to a specific employer.
Correct, Your Honor. And the one
That's how this is how this cottage industry works, right?
Right, and many of them, I mean, Ms. Chow testified, or perhaps it was in her affidavit, she would work for, besides working for the New York City Department of Education, she worked for 7 or 8 agencies at a time, and that is how many of these people work, and that's how they end up meeting each other. If you know, a child getting early intervention may have, you know, a physical therapist, an occupational therapist, a speech therapist, and they'll all kind of
Trifecta.
work together, exactly. And it's fantastically effective, you know. This
Schools
is,
love it. They get like a second hand. They get like extra.
they really do, and it helps these children enormously. But at the end of the day, I know Ms. Sheng was disappointed that Ms. Chu went into competition with her, but there's no, may I finish?
Yeah.
Okay.
Please.
There's no evidence that they accessed their computers, that they accessed their files. All of this was information in Ms. Chu's head from working there. And that's information you can take with you. There's nothing that shows they use the facilities. There's nothing that shows, again, there's a question as to whether some of the confidential information even existed. And there's the only thing that shows.
What about if some of this work was being done on FLA time? Were they using their emails, using their phones? There are claims about that.
So there was one email that it shows was sent during FLA time, and my client says she was on a lunch break at that time. One email over the course of the April to October time period that they worked on this application back and forth with the city. All of my clients said they came to Ms. Chu's apartment, I think it was Ms. Chu's apartment, and I apologize if I'm wrong, after work hours and worked on the application. And I'm sorry, there was one more thing you said, Your Honor, that the
Phone,
email.
there were
Oh, the phone,
phones
yeah.
used
So Ms. Chu testified that she had a personal phone, and then FLA took over payment for that phone and her father's phone. And she reimbursed them for her father's phone, but she used it for both work and for personal. I mean, that's how many people use their cell phones now. It was her personal cell phone.
Okay, thank you.
Thank you, Your Honor.
Just a couple of things, Your Honor. In answer to Your Honor's question, there is no public list of these places, and that's why it took my client 20 years to develop the list that she had. And while she may have had a long list, what Ms. Chu did, Chu was the clinical director of my client's program. She had access to everything. She admitted she had access to everything. They never produced any information relating to the providers that they used on the application out of their files. She had access to everything. And I just want to read you from one of the depositions. And is it true that you understood that you were not supposed to use the identity of the therapist or for your own purposes in competition with FLA? Is that correct? Yes. And all of them basically admitted that. It was not Ms. Lowe who found the providers, and that's all in the record. It was Ms. Chu who they all testified primarily filled out the application. It was Ms. Chu who had hired these providers for FLA and had collected and entered into the agreements with entered into the agreements with Ms. Del Salto while she was still the clinical director of FLA. And the law is clear that this isn't information, even if it's in your head, that you can use. This is, as they all conceded, the most valuable confidential information FLA has. Its providers. And what they did was they took that information, and Ms. Chu admitted she had access to all of it, and they used it. There's no question that these were these providers. That was the basis upon which they got their contract. It was an absolute requirement in the contract, and these were the only providers that were listed. So there's no question that they used my client's resources. And yes, my client was disappointed, but the fact is, when Mia told her she was leaving, Mia Chu, she said to her, but don't worry, I didn't use anything from FLA. I'm not going to use anything from FLA. I'm not going to compete. You know, I did everything legitimately. And my client believed her until she got some information a little while later. She got through a Freedom of Information Act, the application that she used, and it's when she saw that application, says, oh my God, these are my providers. This is my phone number. These are my quality assurance plans. This isn't what any other competitor could legitimately do. The person who was running her office took everything that was central to her company and basically put their name on top. Now, that's not fair competition, and that is a breach of the duty of loyalty, and it is a breach of a fiduciary duty of the key employee that's there, who, by the way, testified that, yes, I wasn't a very highly trusted position, and yes, I did have obligations, and yes, my job was to keep these people for FLA, and she testified, and my job was not to encourage them to leave FLA. All of those admissions by themselves establish all we have to establish for a motion for summary judgments. Agreements have nothing to do with it.
Thank you.
Thank you.
People versus Mark Yates.
May it please the court. My name is Michael Kim Kraus, and I'm a partner in the New York office of Arnold & Porter. Along with the Center for Appellate Litigation, we represent Mark Yates for purpose of this appeal. We did not represent Mr. Yates at trial. We make two arguments on appeal. First, Mr. Yates's conviction for second-degree larceny should be vacated because the people failed to prove beyond a reasonable doubt that Duarte was the owner of the payments at issue. Second, and in the alternative, Mr. Yates's restitution order for over $745,000 should be vacated because he was entitled to a hearing to substantiate that amount.
So why do you think the defendant here had his own business? The Duarte leases the defendant's company, basically taking its receivables at that point, because they're paying the defendant a sum of money for getting your receivables, right? And the monies are coming in, but they're being deposited into the defendant's account. And he says somewhere, I think, on trial, saying that, well, you know, Duarte owed me money, so I didn't think it was a problem for me to hold the money because at some point I was going to give it back to him, but it's it's money they owed me. So why do you think there's an issue that there was insufficient evidence here that who the money belonged to?
Well, the money, Your Honor, I think that there's a couple of things. Timing is important here as well as physical possession. So here, the money that was being paid for those projects was physically in the possession of Mr. Yates and the New York DM accounts. There's no question that there was a split that was supposed to happen between the amounts, and we could concede for purposes of this appeal that there may have been some money that should have gone to Duarte from Mr. Yates and from the New York DM accounts. But
wasn't it all supposed to go, and then the split happened after Duarte had the money in its possession? Or am I mistaken?
That's where the timing comes in, Your Honor. The lease agreement between New York DM and Duarte had been in effect until, I believe, July 31st, 2015. All of the payments post-dated that date. And so there's no question, and I don't believe the people would dispute this, that the lease agreement had expired and it had not been renewed. Mr. Yates was still an employee of Duart, but for purposes of the corporate entities, New York DM still existed and still maintained its corporate identity, both at the time of the lease agreement and then after the lease agreement. And the testimony of the people's own witnesses substantiates that. So Ms. Young, who is the CEO, said that that they would no longer, they being Duart, would no longer be responsible for the expenses of New York DM after the lease agreement ended, which the natural inference from that is that New York DM would have expenses.
When are
would
you
continue
saying the
being-
lease agreement ended?
I believe it was July 31st, 2015 is when the lease agreement ended. And this goes to a point that we make in the briefs, which is the legal agreements here are more confusing and sloppier than I think the people acknowledge in their response. There's no question, as Your Honor mentioned, that there was an entity here that Mr. Yates owned, and then that entity didn't just go away. It still had legal effect. And there's also no question that the companies that were paying the money, so the NHL, the P&G, Madison Films,
Hold
and
on a
AMC
second.
Networks.
I got notes here. When you say the lease agreement ended on July 31st, 2015, arguably anything after that lease agreement ended, in terms of payments, there's a question of fact of who the owner is. But if you look at the NHL project, that, according to my notes, had something of a date of July 17, 2015, which is before the lease ended, right? It's like $271,000.
And that is the invoice, Your Honor. So we concede that.
That's a big number there, right, for grand larceny purposes.
Yes, Your Honor, but the payments themselves were made after the lease agreement.
Yeah, the payments were made, but the payments were made, but before the payments were made, you already knew who the owner of the payments should be, who the rightful recipient of the payments should be in this case.
Your Honor, I think we concede that the invoice was sent while the lease agreement was still in effect.
Okay.
I guess the point we're making is that the payments were made after the lease agreement, but more broadly, that the legal arrangements here were not as clear-cut as it may seem. Mr. Yates was the owner of this business and continued to be the owner of a business even after he engaged in the contract with Duart.
Okay.
I
thank
know
you.
my time is up,
Yeah.
Your Honor.
You have rebuttal time. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Andrew Seawald for the people.
Before you start, I have a question. Should we even be addressing legal sufficiency?
That the defendant's claim is unpreserved. Okay. So, yes, Your Honor, trial, the defendant claimed that that there was a lack of proof that the defendant wrongfully took, obtained, or withheld the money from its owner. That was all that the defendant said. It was unclear that the defendant was claiming that Duart wasn't the owner, rather than contesting that whether the defendant wrongfully took the money. And so, in other words, the defendant did not make the claim, did not specifically articulate the legal sufficiency claim that he's making now. So, yes, I would ask the court to find that that claim is unpreserved. But I would also say that if the court does want to look at the merits of the defendant's sufficiency argument, there's no merit to it at all. This case is actually pretty simple. The defendant was an employee of Duart for the entire period. All of this talk about the lease agreement is irrelevant to his status as an employee. He was out there
So
submitting.
he had a separate company, but he was also at the same time an employee of Duart.
That's right. And so to some degree, that separate company was subsumed by Duart pursuant to this lease agreement. Duart didn't want to buy the company outright because the company had a lot of debt that Duart didn't want to assume. But Duart did want to take the equipment that had belonged to the defendant's company, and in order to compensate the defendant for that equipment, they drew up this lease agreement. But the pertinent fact about the thefts was that the defendant was an employee of Duart for this entire period, and there's no dispute about that. He admitted that in his own testimony. And so when he was out there signing contracts, he was doing so with the companies at question here. He was doing so on behalf of Duart. He signed those companies as a Duart employee. He identified himself as a Duart employee. To the extent that he referenced his NYDM company, he referred to it as a Duart, as like a subsidiary of Duart.
Affiliate.
So he was out there doing business as a Duart employee. Duart employees, besides the defendant, were doing the work on these projects. The work was being done within Duart's offices, and the companies that were contracting with him, they thought they were doing business with Duart. In all of these cases, the companies had contacted Duart. I'm trying to remember the specific facts. At least the NHL case, for example, that the NHL contacted Duart, someone other than the defendant at Duart. They hired Duart. They didn't hire the defendant as an individual. They didn't hire the defendant's former company, or to the extent it still existed, they didn't hire that company independently of Duart. They hired Duart. And yet the defendant went out after Duart was doing the work did the work for these clients. He gave them invoices in which he said, well, just pay me, pay my company.
So he created separate invoices that he wasn't supposed to. Those were in addition to the Duart invoices?
It may have been part of his job to give invoices to the
But they weren't supposed to say pay him, they were supposed to say pay Duart.
Exactly. And when he submitted duplicate invoices to Duart, they were different. He represented to Duart that he was billing correctly. He also changed amounts in the invoices that he submitted to Duart that were supposed to be duplicate invoices. He listed different amounts to try to cover up the fact that he was receiving these payments directly. So this was not some sort of contract dispute. This was not any money that NYDM was ever entitled to in the first place. This money all belonged to Duart, and to the extent that the defendant was entitled to any of it, it was as a Duart employee.
It looked like the jury rejected the comment. I mean, I got in my notes here, the defendant testified felt fairly well justified in holding payments because Duart was at certain points 8-9 months behind paying defendant commissions and lease payments. I mean, that was rejected by the jury. I mean,
right, and you can't do that anyway. I mean, these payments were Duart's, rightfully for Duart, and if they were slow, if paying him his commissions, that would be a separate matter.
Thank you.
And I would just say briefly that the restitution claim is unpreserved as well, completely unpreserved. But I would also say that there's ample evidence in the record about the dollar amount here. The defendant admitted that dollar amount in his own testimony, at least as an approximation.
Yes, right.
And
Okay.
so there's no reason for a restitution.
Thank you.
Thank you.
I'll start with the preservation issue. With respect to the larceny claim, our position is that Trial counsel below stated, no one from Duarte testified about any amount taken in an unauthorized fashion when they moved after the entry of the evidence and then renewed that motion at the close of trial. And our view is, or our position is that that's sufficiently clear with respect to the larceny count to preserve that argument. And in the alternative, the interests of justice, we believe, do justify reaching that question. On the second issue, the restitution hearing, it's not disputed that we're not disputing that the calculation of how much money went into Mr. Yates's accounts and NYDM's accounts and how much went back to Duarte is accurate. The question is, was there additional money that should have been taken off of that restitution amount based on the evidence presented at trial? And the answer to that is yes.
Well, did you ever put in any testimony to show that?
There is testimony and exhibits in the record, Your Honor, at trial that shows that there's an NYDM commission of 8% of gross revenue generated by the accounts each month, as well as a sales commission of 5% owed to Mr. Yates, as well as what Mr. Yates said at trial, which is that they were 8 or 9 months behind in paying their sales commissions. So if restitution is intended to put the victim in the same position they would have otherwise been, that amount should have been taken off the $745,000. The judge did not do that. And if there is record
How much would that amount be? About $60,000 or change?
It's about 13% of $745,000, Your Honor, which is close
But
to...
the amount that it is alleged that was taken was something in the nature of about $806,000.
It was $745,000.
Well, that's the amount of restitution. But wasn't it alleged that he took more than that?
No, Your Honor, because he gave back $60,000 to Duarte. So they had, in calculating restitution, they already took off the $60,000 that Mr. Yates paid back to Duarte on the NHL contract. So the amount of restitution represents the total amount that Mr. Yates, the jury found, had misappropriated. But what our argument is that there's another $100,000 or so. There's no hearing, so we're not positive. That should have been sales commissions or commissions to NYDM that should be taken off of that restitution amount. There's also the issue of insurance having reimbursed a lot of this money to the victim. And there's also the issue of, at trial, Mr. Yates testified that there were additional records. So there could be some limited discovery and some limited hearing that would better substantiate such a large restitution amount.
Didn't the people in imposing that point that you just made argue that your claim for commissions was forfeited by your client's refusal to follow the proper protocol to be entitled to these payments? And I guess the court bought that?
There was no discussion of that on the record. That's what they're arguing now on appeal. But that would be an issue that could be addressed at the hearing. They could make that argument. But if restitution is intended, to put the victim in the same position they would have been in, that's a question of fact of whether it would have been forfeited in that manner.
Thank you, counsel. Counsel, you're here as a pro bono counsel for Honorable Porter?
Yes, Your Honor.
Or thanks you for your time and efforts. Appreciate that. Thank you.
Thank you, and I'd like to recognize my associate, Sarula Kubi, as
Perfect.
well.
Thank you very much.
Thank you.
Next time she can argue the case. E3 East 54th versus Chitaris.
Good afternoon, Your Honors. I'm Attorney Donald Harwood Reef on behalf of 3 East 54th, New York. This was an action brought by a building owner against a guarantor of a lease. It was a restaurant.
Yeah, it was an unopposed motion for summary judgment, and the guarantee, or at least the funds you were seeking, fund of guarantee, were outside of the administrative code's restrictions, right?
Right, and if there were any question, it was frankly resolved last month, and I believe Justice Moulton was on the panel. The case is Tamar Equities Corp. versus Signature Barbershop. In that case, there had been a division of authority. Judge Leibovitz, who we had relied upon in Mansion Realty, saying, well, of course you can recover for amounts that are post June 30, 2021. The Diamond case from the lower court seemed to indicate otherwise. Justice Getz in this case was relying upon Diamond, which obviously is no longer good law. So in this case, just to be clear, the complaint never asked for pre-July 1, 2021 damages. It wasn't even a mix like it was in this court's decision in the 7th Avenue case. So based
You
upon
only
that...
sought, I'm sorry, you only sought rent owed from July, post the guarantee period to October. That short period for $113,000 roughly. So that was due and owing. You didn't accelerate under the lease based within the period of the guarantee law.
But not, even the complaint here didn't ask...
That's what I'm saying. You
guarantee.
sought exactly what would be appropriate without triggering any problem, regardless of whether the guarantee law was
It's
good
not
or
a
not.
trick question.
No. Correct.
Okay. Thank you.
Okay, thank you.
Brigham versus Cruz.
Good afternoon, Your Honors. May it please the Court. I am Thomas Brigham, the petitioner appellant pro se in this appeal. The core issue being argued in this appeal is that the court below granted a cross motion by Respondent Cruz to dismiss the petitioner's original verified petition, which was motion sequence 001, while in the same order granting the petitioners leave to amend the verified petition, the amended verified petition, and accepting and deeming that accepting as sequence 003, so that then the court granted the motion to dismiss sequence 001 on a verified petition that no longer existed because it had been superseded by sequence 003, the amended verified petition. The lower court apparently did not look at the, when they granted 003, did not look, or they would have appreciated how very different it was. It seems like somehow there was an equivalence if a motion to dismiss 001 is then used, cited as dismissing
The way I look at
003.
it, sir, the way I look at it is the Supreme Court treated your amended petition as the operative pleading, right? So that's basically saving everyone.
Well, that doesn't make any sense, Your Honor, because the caption was amended, the facts were amended, the new facts occurring both before and after the original verified petition, the parties were amended, and the relief sought was amended. It wasn't, it was essentially not at all the same. And so there was no cross motion to dismiss.
Mr. Brigham, but it was your amended petition, right?
Yes, and there is
Okay,
no
so
motion
let's
to dismiss
take a breath
the
for a
amended
second.
petition.
It was your, and you were trying to advance a different kind of argument that was advanced in the earlier petition, correct? In the earlier petition, you were basically saying that, and I use the term 963 or whatever, that whole narrative expired, and therefore they shouldn't consider it, and ball game over. In the second petition, you're advancing a claim that misrepresentations were made in the underlying application, among other points, correct?
Yes, that's...
Bear with me. Okay, so let's go a little further. And then when you started this Article 78 to challenge all that, you also concomitantly at that time had a pending administrative appeal with the law board, correct?
Yes.
Okay, so it's my understanding that if you have a pending administrative appeal with an administrative agency that had not determined it yet, and then you go ahead and start an Article 78 to judicially review that whole process, that would be premature because you didn't exhaust your administrative remedy. Do you agree with that?
No, because the exhaustion exception is, I don't think you could possibly have a more high relief than this. The Cruz is sitting there filing, saying that AD 0121 was never filed. She concealed it. It doesn't exist. He didn't file anything. After 2 filings to the lower court, at the appeals court, Cruz finally admitted that that was untrue and that she was concealing it. Jaffe respondents, in their first filing, concocted a whole false thing about that TR1 were selectively lost on the 3rd and the 4th floor in order to not face the evidence that was presented on the 3rd floor. And this was just completely absurd because there is no set of TR1s, and that somebody misplaced the TR1 when they moved to Texas, when in fact the special inspector withdrew all of his special inspections.
Thank you, sir.
Having re-inspected and saw that
Mr. Brigham, you have response time. Thank you.
Okay.
You got it.
Good afternoon, Your Honors. May it please the Court. Diana Lawless. I appear on behalf of the Martha Cruz, who's the Executive Director of the New York City Law Board. And our position is Supreme Court properly dismissed the petition. Justice Owing, you mentioned the filing.
Yeah, that, I got to tell you, you can't make a filing like that a day before the argument, and what do you hope to achieve with that filing? Because the way I see it from my vantage point, I'm looking at a static record that has as an issue a failure to exhaust administrative remedies, right?
Right. I apologize, Your Honor. I did it in good faith in order.
Well, I know, but this was the November decision. November
Again, Your Honor,
2023.
I will say in good faith, the law department and the law board and every single client agency are not the same entity. I could have done more to ask my client more diligently and more effectively about when it happened.
This is like a really awkward.
Well, I don't think it's awkward, Your Honor, because I think the reason I said it was just to prove that, I'm sorry I interrupted you, Your Honor. It's just to show that he doesn't have a futility argument, that he could still appeal an administrative determination. I just wanted to make clear let the court know that there was an administrative decision issued.
Right, but what we have in front of so for our purposes, at least from my understanding, is I have to, in other words, what the information you provided to us yesterday afternoon, it's outside of the record. So what we have here, we're still looking at a record that doesn't have a decision in it.
No, so if Your Honors do not need to consider it, I don't think it changes our position. I apologize again. I was trying to act with my duty of candor to the court. Obviously, that failed here, but I think
didn't fail. It just caused a little bit of a little.
I apologize. I will also mention that this particular applicant keeps filing many applications before the law board, so it's actually very hard for the law board to keep track.
Okay.
But I think that nothing changes when as Justice Schulman said, at the time the petition was filed, at the time it was dismissed, he had not exhausted.
The way I understand his argument, his main argument, or at least his position, is that Supreme Court erred in treating the amended petition as the operative pleading because there were new things that were done, there was a new caption. What was going on here? I'm not so sure that I think in that sense, it was still proper for Supreme Court to do what it did, right?
I agree with you. I agree with you, Your Honor, and I think it's because what happened was, and this comes into like my first argument, which is that he has not preserved any of his arguments because my client moved to dismiss. In response to the motion to dismiss, he tried to file a new petition that got rejected. He then moved for leave to file the amended petition. He did not. He did not raise any arguments that opposed our motion to dismiss. He just added some things, and I think by his own admission, yes, he took out the Department of Buildings about challenging a different application, but it seems to me that he just added more things that happened.
So, yeah, because ultimately it's still the exhaustion of administrative remedies.
Correct,
That's
and
the
we
key.
opposed his motion.
So what's your response to him saying that, well, this particular case or matter falls outside the exhaustion of administrative remedies?
Right. Well, I mean, that was one of the reasons I submitted the order. But
well, aside from
setting that
it's
aside,
a constitutional argument.
Right. So the constitutional argument, it's not. It has to be a policy or systemic failure, and he doesn't have that. Even if he says it's due process, it's not enough. The Court of Appeals in Schultz said a constitutional claim that requires the resolution of factual issues, review at the administrative level, is addressed to the administrative agency. And I think even if we look at what he submitted, you know, he submitted an opposition, right, to the loft board before the administrative review, which was about a very limited thing when it was the opposition to this new filing by the landlord, the owner. He just said, oh, the Department of Buildings couldn't have ever issued this permit, so this whole thing needs to be vacated. That's the only thing he ever said to the loft board. That's when the loft board issued the letter at issue. That was the only argument he raised at the time. Now he's trying to bring this Article 78, raising a whole host of other arguments that he never presented at that time.
Thank you.
Thank you, and I apologize for the confusion I caused. It'll be a lesson for the future.
Thank you.
Oh, sorry. That's okay. May it please the court, my name is Ethan Cohen from Rosenberg and Estes for the respondent owners. I would second everything counsel for Director Cruz said here. The appellant failed to exhaust administrative remedies here, admitting that he did file an appeal of the Director Cruz's decision. So I think that admits that there was no futility, there's no exhaustion exceptions that apply here. If the court has any questions as to the merits other than that.
Right. No, I don't think so.
Thank you, Your Honors.
Yes, just in reference.
Mr. Brigham, can you go to the lectern, please?
Oh, yeah.
You go speak.
Just in reference to this filing this docket of A121, I think that this portrays what the exception, how she takes this order and files it yesterday when this also fraudulently conceals the existence of AD 0121, which was timely filed. So it's still going on, and she's doing it yesterday, trying to get a benefit from what is a false, and she's admitted now in the appeals court that this is false. And then she files it again. And Jaffe, respondent, and the loft board colluded together with the ex parte emails where they made up false statements about the special inspections and that there being multiple special inspections and that they're being split between two things and that my floor being could be removed. That was all ex parte. There was no way for me to have participate in that. That was signed, sealed, and delivered with false information that they filed their own, let leak through their own information where their own special inspector withdrew. They contradicted their whole story accidentally, but the whole point was that all of this was done ex parte with people that had worked together in the past, that had financial interests together, that and it was a concerted effort to make false statements, and there was no way for the petitioner to squeak into that with any kind of justice when they are ex parte lying. Then she today files the thing that already admits that this is a lie, and they're still filing it.
Okay, thank you, sir.